This week has been a much better week in terms of the stability within the country. And I think we all can attest to that, feeling a lot safer. I'm in Durban, and that's where a lot of the stuff was happening, in fact. So I feel a lot safer actually now. And I think that's what we want as South Africans, just to feel safe. We have a jam-packed session with a lot of questions. So let's get into the first question. My property has been put up for auction due to the fact that I owe money to a creditor. The auction is set to occur in the very near future. I have managed to free up some funds, but it will only become available to me a few days after the auction. Now the question is, can I attend the auction and bid on the property myself? I do currently have enough money for the deposit. However, if not, I'm not allowed, can I get a third party to bid on my behalf and pay them once my funds become available? Bruno, what say you?
Sounds very similar to a case I dealt with. So let's just break it down to slightly smaller pieces so it's a bit more bite-sized and people understand the process as it goes along. Because actually going on auction to bid on your own property is something entirely different. So let's maybe start off with somebody's properties being taken up on auction. How do you approach it from an investor that's attending the auction? How do you approach it from a debtor perspective whose property is being auctioned off, right? So now, long story short, if the property's been set down, all the notices have been served, the sheriff's about to sell it on auction. The practice of the bank, and this is practice, so the banks can deviate from this, they just really do. The practice from the bank is to say, if you're able to pay your arrears all at once, so cover your arrears fully, they'll probably take the property away out of auction. So what we mean by arrears is what amounts have you been failing to pay? So it has nothing to do with what your outstanding bond amount is, because that's a different amount. That's what you owe the bank in total over the next 20 years. But if you've missed 3 payments over the last 3 months or 4 months, the bank would want to catch that up before it ever stops the auction from taking place. I have seen certain compromises, so not the full amount, 75% of the amount or 50% of the amount. And you as an investor can also utilize this to your advantage. So if you're intending going on or buying on auction and you see that there's a property there and you approach the owner and you guys can reach an agreement where you make an offer directly to that owner, you can approach the bank and make them an offer to say that you're going to cover the arrears or 75% of the arrears or whatever the case is, to stop the auction from taking place. So that's typically how one goes about to stop auctions, right? Now, the next thing we look at is what we call reinstatement in terms of the National Credit Act. Now, this is quite a crazy one because the legislation reads very strangely. Case law has looked at it and made certain confirmations, which, respectfully, I don't actually agree with, because I actually had a case where I had to go into this in quite some detail. But long story short, to put it simple for the viewers, if your property's gone up on auction, right, and this is where the dispute comes in. If the sale's taken place, there's case law that says that even if the sale's taken place, if you can cover your arrears, and you can go to the bank and ask them for the settlement figure and cover the full amount, that the bond can be reinstated. And that's an NCA thing, right? So it's quite strange because there's different schools of thought as to whether you can actually do this after the sale, but before the transfer, or if you have to do it before the sale takes place. But the case law, the way that it reads at the moment, says if after the sale, the property's been sold, but you ask for the settlement figure, you can actually go to the bank, settle the arrear amount. So as the debtor, there is a possibility of doing this without actually attending the auction and bidding on your property. And then lastly, what this specific debtor wants to do is go and bid in his own name and try and buy the property. And typically, if the debtor pitches up at the auction, the sheriff is not going to allow him to bid. The sheriff does have a right to do this, especially because of the circumstances of the case. The sheriff does have a right of admission. I have seen people try do it through third parties. It's not that it's illegal because you're not representing that you're not doing it. So you can actually get someone to do it. Just bear in mind that whoever bids on that property is bound. And if they bind themselves as purchasers and they can't perform, they're going to land up getting themselves into trouble because you're going to pay a deposit. And if something goes wrong, they're going to want to claim that deposit from you as damages. The sheriff's going to keep his commission. And if that property resells later, and this is sometimes what you find, and I've seen this with debtors, they go to the auction, the price gets pushed up, so it sells way more than it should. And then if it gets sold a second time round, it sells for a lot less. And now the difference between those two purchase prices become a problem because that comprises damages and somebody can actually sue you for those damages. So yeah, I'd be very careful doing that, but those are basically the three scenarios that we can paint.
Cool. Thanks, Bruno. I think let's move quickly on to the next question, which was asked by Celeste. Celeste has a friend that is renting a residential property. The landlord has placed many restrictions in place, such as no visitors allowed. They have to use a handyman who was selected by the landlord. They have to use the handyman's wife to clean the premises. And I think the list goes on. She says that the restrictions have led to tensions between the landlord and her friend. The landlord has now given them notice to vacate based on what appears to be breaches of these excessive restrictions. What rights do Celeste or does Celeste's friend have in this instance? Cilna?
Yes, so that's a very interesting question because we see that quite often. Remember, the easy answer is a landlord does have the right to impose certain restrictions as long as it forms part of the lease agreement. Something like you're only allowed to use this contractor to fix things in the property. 100% allowed. That doesn't even have to be part of the lease agreement. If there is damage to the property that has to be repaired by the landlord can definitely pick who he wants to use. He can't compel the tenant to do things, for instance, use the handyman's wife as the domestic worker. That is far outside of the rights that a landlord has. Definitely not. Restriction on visitors, I have seen this many times. You can, as a landlord, make certain provisions. For instance, you're not allowed to have parties outside of the complex allowed hours without prior arrangement, something like that. But you can't restrict visitors to a property, definitely not. You can't say, I've even seen landlords say things like, somebody is not allowed to stay over. You're renting the property, you have the full right of occupation of the premises. And if somebody comes to visit you and they stay over for a night or two, or even a week, it's really okay. The problem comes in if that person is no longer a visitor. That raises a whole new set of questions. If that person becomes an occupant, obviously the landlord is entitled to and should contract around the avoidance of overcrowding. That is not just his right, but also his obligation. This landlord, I must say, because there are some elements that he is allowed to do, but then some overreaching a little bit, it makes it difficult to simply act on it. I must say, if it isn't, the answer to the question is, if these provisions form part of the lease agreement and the tenant agreed to that, and now suddenly she doesn't want to comply with that, in that case, she is in breach of the lease agreement. Because at the time of signing the agreement saying, lekker, I won't have visitors, we have a principle in law called caveat subscriptor, which is you need to be careful as the person signing a contract, because the terms that you agree to in terms of this contract will be applicable to you. Obviously, as soon as something becomes contra bona, so against good morals, for instance, not allowing somebody a visitor, enforceability becomes a bit of a dispute there. But If this lease agreement did contain these weird provisions, unfortunately, the tenant could be in breach of the agreement. There is an argument to have around the enforceability of the of those terms, but still now we have a dispute. However, if these provisions did not form part of the lease agreement, so this is now stuff, the lease agreement said nothing about this, and the landlord is now from the side coming in with the weirdest things, and the tenant is like, yeah, man, this is not going to happen. Then the tenant is not in breach, because remember, you can't be in breach of a term of an agreement that does not exist. So in that situation, the truth is the landlord is in breach if it doesn't form part of the lease agreement, because remember, essentially of a lease agreement, one of the terms is that the tenant must have undisturbed use and enjoyment of the premises. Now, what this landlord is giving is a lot of things, but not undisturbed use and enjoyment of the premises. So for this tenant, I would do one of two things. Either one, place the landlord on terms, give him either the time period in terms of the lease agreement, but to be honest, I can't see this lease agreement containing a clause dealing with the landlord's breach. With all respect to a landlord, I don't know, yeah, it doesn't sound like the kind of landlord that will have a breach of the landlord clause in his lease agreement. So in that case, just for safety's sake, I would probably give him 20 business days to remedy his breach. Please, Mr. Landlord, give me undisturbed use and enjoyment in 20 business days, failing which I'm going to cancel. But now the damages claim falls on the landlord, not on the tenant. The other option that the tenant has, and I would not recommend this one, would be cancellation in terms of section 16 of the CPA, 14. Where was my 16 from? Never trust my numbers or my months. Section 14 of the CPA. And that says a tenant, well, a consumer may cancel a fixed term agreement by giving the supplier, in our context landlord, 20 business days notice. But if this tenant does that, it would mean that the landlord would be entitled to claim damages from the tenant. So I would not suggest that cancellation, but I would probably go and see a property attorney and do a letter to the landlord placing him on terms.
There's a funny situation that actually arises from this, and I just thought I'd mention it because it's very similar application of the law and rules. And I did a talk on this the other day regarding short-term leasing, especially around like your Airbnb model and body corporates and how body corporates interact with hosts and how they try implement restrictive conditions on hosts, also regarding things like visitors and the like. So it's actually the provision of information prior to anyone being allowed into their state. And there is case law that also speaks to it actually speaks about like what's reasonable and necessary. So obviously it's slightly different because with lease agreements, we have the Rental Housing Act that already kind of sets the standard. And obviously when it comes to contractual provisions, when you enter into the contract, you also now need to be aware on what you're actually contracting in. But with body corporates, for example, especially if they change their rules later, where you're already an owner using it for short-term letting and they change the rules later, whether you're entitled to challenge these rules. And the case law upheld the rule. So it agreed with the body corporate that it was allowed to implement that specific rule, disallowing people from using the Airbnb in the body corporate. However, it didn't make it as standard that can be done all round. Every case or all circumstances need to be considered. So if the body corporate can prove that it's necessary, or the owner can prove that it's unreasonable and isn't necessary. So for example, if somebody uses a reason like security as the basis for this, but there's no evidence to show that not having an Airbnb would improve security, or having an Airbnb would cause security issues, a court can consider that to see whether it's actually reasonable to have that rule in place. So it's just interesting because it plays very closely to this lease agreement contra bona mores, whether a clause is enforceable or not.
Oh, thanks, guys. I'm going to move on to a question that was asked by Priscilla. Priscilla says, my husband and I sold our late father's estate. We had someone looking after the place, and all parties had verbally agreed to be out by a certain date. Nevertheless, that certain date had then come. I think it was today, in fact. And the caretaker then says, look, I have nowhere else to go, so I'm going to stay here. The caretaker also then goes to the police, and the police advise the caretaker, whether correctly or incorrectly so, I think you guys will let us know, that this caretaker can actually stay on the property until they find a suitable place to live. The estate agent now, because the property has been sold, needs the keys as the new owner would like to move in. So Priscilla asks, can I go and take the key? Can I just go and take the key from the caretaker and then hand it to the agent? And then also, can I approach the police and say, listen, please escort me to the property, and can we remove this person? So Priscilla wants to know what are her rights in this regard. I don't know if I'm going to throw this to Bruno or to Cilna, but you guys can decide who's going to take this one. Who wants to be the bearer of bad news?
I think it's a very quick answer, luckily, Bruno.
Yeah.
Or me.
Yeah, absolutely.
Let's take half off. I'll do the before the police, and then you do the police part. How about that?
Nice, cool. Sounds good.
Well, the thing is, remember, any person that is in occupation of a property, in terms of the Prevention of Illegal Evictions Act, the definition of occupant is a person who uses a property for permanent or temporary shelter. Now, this caretaker has been living in this property, so the caretaker is without any doubt an occupant in terms of the definitions of PI. No doubt about that. So to just take the keys and give it to the estate agent and let the purchaser move in, that card's not going to fly. That is definitely illegal. And the caretaker, maybe I should leave this one for you, what the caretaker can do if that happens. But then we're going to go to spoliation. But you can have that. So you definitely can't go and fetch the keys. Bruno will explain to you what's going to happen if that happens. So definitely the only way of getting this done, unfortunately, is through an eviction. Remember, the estate does have locus standi to attend to this eviction. If transfer already took place, did it, Chris? Yes, no? Yes. So the purchaser does have locus standi to attend to the eviction. The estate may or may not, depending on the terms of the offer to purchase, be liable for payment of the cost of the eviction. I can't say that. I can't answer that question without seeing the offer. But unfortunately, only option out of this would be an eviction. And please remember to use a specialist firm, otherwise it's going to take forever. Yeah, okay, Bruno, absolutely. If they don't, can they go to the police?
All right. So I think what Cilna's alluding to is what we call spoliation. So long story cut short, and there's plenty of case law around this topic. The reality is that you cannot take the law into your own hands. That's why this concept exists. A lot of people think it's unfair because even if you've got a right to do something, you can actually give back a specific property to someone who has no right to it simply because you took the law into your own hands. It's to protect the law, it's to protect the integrity of the courts and the way that justice is actually served in our country. And it's not South African based, so it's actually a Dutch principle. So it's something that's been tested over time. We tend to find it's unfair in the practical sense because sometimes our courts take really long to enforce rights, and we've got certain legislation like PI that gives that requires long periods and notice periods, and it takes a bit of time to actually get an eviction completed. But this principle of spoliation is there to protect everyone, and I can give you some horror stories on where people actually really benefited from it, where they needed it to come to their assistance. So if you take the keys away from someone, well, it's interesting enough because if you take the keys, there's still an argument that you haven't dispossessed them of the properties. You've simply dispossessed them of the keys. So, arguably, arguably it's simply a set of keys, right? But as soon as
I'll argue anything around Bravery Manu there. Sorry.
Fair enough. Look, so like for instance, I was reading on something today, like even just the threat of dispossessing someone over something else, like the courts treat it based on the circumstances. But hypothetically, let's look at the keys, or let's look at actually removing the person from the property. That's simply spoliation, right? So as soon as somebody would go there with a set of keys and would lock the person out and they wouldn't be allowed access to the property at all, that would be spoliation. So taking the keys does cause that problem unless the person simply sits there and doesn't move from this property, but they would be able to claim the keys back at the very least. SAPS doesn't count because an eviction done by the SAPS isn't lawful unless it's in terms of a court order, and that's the reality. And typically the SAPS would only do this in order to assist the sheriff in execution of an eviction. So it's not the SAPS's job to do evictions unless the court has kind of authorized them to. So yeah, there's no authority there. PI has to be followed. And to Cilna's point, just one thing that I wanted to mention that's quite interesting is you often get questions regarding the definition of occupy in terms of PI, and people would ask and go, oh, but hold on, a caretaker that wasn't supposed to live on the property, for example, that was only supposed to be there a portion of the time and take care of the property. Remember, it's not what the intention it was for this person to be on the property. Maybe he wasn't meant to occupy the property, but it's what he is right now, which is a occupier. So if he deems his property to be with a level of not permanency, but like he's living there, he's residing there, then he is an occupier in terms of the act, even though it wasn't your intention to give him that right.
That's a very valid point.
Oh, thanks, guys. So we have some time left. There's a question here by Jen Casey. She asks, I bought a sea view property on an estate. The estate is now planting trees which will completely obscure or block my view. Where do I stand legally? Now, obviously, there's an element here because a sea view apartment holds value by virtue of the fact that you can see the sea. So what are the rights here of Jen? Cilna?
Says Chris all the way from Belito with a sea view. Do you have a sea view? Don't answer me. Don't answer me. We are in Thanks, Chris. That's what friends do. We lie to each other. Thank you. I feel the love. So a sea view is a very important thing. Okay, so not important in the context of if you don't have a sea view, bad things are going to happen. A sea view is a very pleasant thing, and it does add value to a property without a doubt. So we do have a lot of case law around building restrictions. So in most cases, unless your title deed specifically has a restriction, a height restriction or something like that, that compels a certain, that gives you the right to a view, a right of view. Usually, building-wise, you can't interdict and you can't restrict unless it's going to really prejudice within the limits and the bounds of the existing title deeds. Usually buildings, you can't restrict. Trees, on the other hand, is prunable. The thing about a tree is, just because it's growing, well done for people who can keep plants alive. That's amazing. I'm not that person. But if you can keep a plant alive and the tree is growing and it's restricting a view, we've had 3 conversations on Wednesday webinars so many times. I think we talk more about trees than properties, but trees are definitely a thing for the reason on property. Either it causes a problem for the neighbor, whether it's a view problem or an encroachment kind of problem. The tree is hanging over the boundary wall. In this case, definitely. Depending on the height of the trees, but I mean, a good 3 meter tree is a proper tree, the height of a house, a tree can seriously still do his tree thing, which is create oxygen for us, on less than like 4 meters. So you can prune a tree to a point where it doesn't restrict the view. And for that reason, my opinion, Bruno, please argue with me on this one if you disagree with me. But in my opinion, I definitely see that you can demand that the neighbor prunes the trees to the point. So this estate prunes the trees to the point where it does not have any overly impact on your view. I'm very happy with if there's a little bit of tree, you know, and then C. I don't think you can say remove all the trees. I don't want to see any tree. I just want to see C. The sentences is starting to be more amazing. It's going to be your turn now. These are amazing tongue twisters. But so I definitely think you can demand pruning to the point where you can see the sea. To you, Bruno, good luck with this tongue twister.
To see the sea. To see the sea. No, look, I agree with you completely. So the only scenario I can see that would cause any potential issues would be, for instance, exactly to your point, if a neighbor, so if this is within the estate and the body corporate's planting trees because it wants to pretty up the body corporate, you would have a lot of rights to be able to interfere with this decision, make sure that if trees are being planted, they're being planted strategically in places that wouldn't impair views, that they get pruned in a specific way. So the answer is actually easier when it comes to dealing with it with a body corporate perspective. If it's being dealt with using neighbor law, that's sometimes where it gets very frustrating. And I think we've had this discussion where neighbors can be very difficult people, lack of better words. So if a neighbor, for example, is because of a certain slope, they're trying to plant a tree intentionally to give themselves privacy, and you feel that this tree is blocking your view, you're going to end up having issues, because remember, it comes down to balancing of rights. Because with things like this, there's no specific rule on this is how big a tree can be, and this is who's entitled to do it, and if they don't, then this happens. Like there's a lot that gets taken into account when it comes to this, and if one person feels they're entitled, the other person feels they're entitled, the court would look at it, go, well, who is? And they would give a decision based on whose rights are being prejudiced more than the other person's rights, and if there's a way of actually getting it sorted out. And so you may find certain issues with neighbor law if their tree is serving a purpose and impacting you at the same time. But the odds are slim in these specific type of circumstances. We tend to find that these issues arise more with buildings, and like Cilna mentioned, with buildings, that's not something that we can really do anything about.
I just want to ask a question. Does the same apply if there is C blocking your view of the trees? Never mind. Just forget that.
You see.
There's time for one last question, a bonus question, right? It's asked by Susan, and Susan says, if a person erects a Wendy house with a bathroom and a kitchen and a water supply and electrical supply on a property for the purpose of renting this property out, well, it's a Wendy house. So I think the one thing there is it's not necessarily a permanent structure. We bear that in mind. She wants to know, is it necessary to have plans drawn up and approved? Sorry, in my forgetfulness. Cilna.
Okay. So I must say, on this one, I think this question is a little bit more town planner, architect type question than purely attorney question. Attorney answer, I would say, I would be careful about zoning. Remember, your specific zoning limits you to the amount of space that can be under a roof. I've seen there was an answer on the group around the roof situation. That's relevant to zoning. It really is, because you can only cover X percentage of the earth under a roof, and when the house does have a roof, that's a zoning issue. Building plans relates to at least something with a foundation. Say, for instance, you put up a carport or something where it's a roof, but there is no foundation. You do not need building plans for that, depending on what it is. This is why I'm saying don't rely on attorneys for the perfect answer on this one, because town planners are the better people to ask this one. But in most situations, remember, there's always exceptions to every single rule. That's why we study 1 year on the rules, and then the other 3 to 4 is just exceptions to the rules. So the general rule would be, if there's no foundation, so if it's a temporary structure, you wouldn't need building plans. Be careful about your zoning, but when it comes to details of this, especially because you are renting it out, I would probably take the time to just quickly ask this question to a town planner. An architect would probably say, what? A windy house? But you can still ask them. But I would probably take the time to ask a town planner this question. Maybe we should have a special edition episode and invite a town planner.
Yeah, sounds good. Yeah,
I
that'll
don't
answer
know
a lot of questions. Yeah, I've got one. So yeah, we can. Yeah.
Yeah,
Have you been
let's.
planning towns, Bruno?
What's that?
Have you been planning towns? I'm just
You
joking.
won't.
It's
You
another
won't
silly quote from
imagine
me. I don't know.
the amount of fights that you actually need a town planner for. Because Cilna's so right. It's not a legal issue. A lot of the stuff. So guys will approach and be like, "Oh, but we're having this fight with the municipality over A, B, and C." And you literally need to get in the town planners to ask them, okay, wait, but what is the requirement? Especially because like different policies apply to different areas. So some areas, in the same municipality, they want more densification. Other areas, they don't want densification. So even in those areas, they have different policies that apply on whether they give consent and like what building plans look like and what people are allowed to build. In some places, they won't even approve your building plans if you've built and it looks like something that you should be rezoned for. So then they make you do the whole rezoning process before allowing you building plans. So yeah, I mean, thank God for town planners.
Yes. And
God.
architects.
And lawyers.
Oh, especially lawyers.
And our viewers on that note, because guys, it's so good to have you all with us. We've reached the end of tonight's webinar. As always, thank you for being with us. Thank you for posting so many questions in the group. I encourage you to post more questions in the group, message us directly, and get in touch with Cilna and with Bruno if you have any concerns that you might want to raise and take further. Guys, it's so good to have you with us. I look forward to seeing you all next week.